Thank you, Chairwoman Baker, also Minority Chair Farnese, and honorable members of this committee. I want to thank all of you for the opportunity for Dr. Anthony Simone and myself to be here and testify before you today. As Dr. Simone can't be here in person with us, his statement was attached as Exhibit A to the written testimony submitted here. First and foremost, I want to thank this committee for granting me permission to address both mental health and some of the firearms-related issues that are being discussed nationally. I understand that my written testimony may be a bit longer than some of the members may prefer. However, based upon my research, I believed it necessary to provide this committee with all of the research and supporting evidence related to the three most paramount issues relating to the epidemic of violence that we are seeing across the United States, which are the proliferation of doctors prescribing SSRI drugs, the breakdown of the family unit, and the stigmatization of mental health treatment. In that vein, I understand that this committee would prefer that I limit my verbal comments to 5 to 8 minutes and that the remainder of my time be allocated for committee member questions. As I could have easily written 100+ pages of testimony on all the issues that are being discussed nationally, I want the committee members to know that I specifically limited my written testimony, and they should not feel limited in asking me questions to topical areas discussed in my written testimony. I am more than happy to address Mental Health and Procedures Act or firearms law questions that any committee members may have. With that being said, and understanding that my time is short, I would respectfully ask this committee to be the first in the nation, take the groundbreaking steps to issue subpoenas to all drug manufacturers who produce SSRI drugs and force them to disclose the studies they have relative to the side effects of SSRI drugs, including but not limited to aggression, violence, and suicide, and the differing effects of SSRI drugs on the juvenile as compared to the adult brain. If you've not had an opportunity to read my testimony or not inclined to, I urge you, at a minimum, if you care at all about your family, your loved ones, and your constituents, read the declaration of Dr. Bregan from 2001, which was attached as Exhibit C to my testimony. If that does not have you concerned about the lengths the pharmaceutical industry will go to deceive and take over the FDA, and the absolute lack of concern for individuals taking their drugs so that they can profit off these drugs, I guess nothing will. I implore this committee to be the first in the nation to take these necessary steps to force disclosure of studies that Big Pharma is hiding from the American public. If there's nothing to hide, Big Pharma will willingly provide these to this committee. However, I suspect this committee will find that it will be forced to enforce the subpoenas, and that alone should tell this committee and the General Assembly all it needs to know about the harmful and deadly side effects of SSRI drugs that are known by the drug manufacturers. Instead of addressing the real 100,000+ pound pink elephant that's in the room, we have proposals to criminalize the failure of an individual to report a lost or stolen firearm, thereby re-victimizing a victim while doing nothing to curb violence. Instead, this committee should be looking to enact immunity for anyone who reports a lost and stolen firearm, so that counties like Philadelphia will be precluded from revoking an individual's license to carry as a result of notifying law enforcement of a lost and stolen firearm. We also have proposals in direct defiance of the constitutional right to due process to enact extreme risk protection orders that do nothing to actually address the mental and behavioral health issue of the individual to which they relate, but rather only seek to strip a constitutional right from an individual, and where no psychological evidence needs to be submitted to support the alienation of a constitutional right from the person. We have an unenforceable mandatory safe storage proposal directly contrary to the U.S. Supreme Court's dictate in Heller that a person has a right to keep a firearm in the home immediately accessible for self-defense. And finally, we have proposals to require universalized background checks, which serve no purpose, as even self-professed Gun control advocate Garen Wintmoot admitted and is cited to in my testimony. They only seek to restrict law-abiding citizens' rights to keep and bear arms. Perhaps most importantly, none of these proposals seek to address the underlying issue. Let's be the first in the nation to uncover the true root cause of the epidemic of violence across the United States. Let's investigate the true side effects of SSRI drugs. I call upon this committee, as specified in my written testimony, to take these steps, enhance the protections afforded by the psychotherapist patient privilege in 42 PACS 5944, and require notice of the right to be voluntarily committed. Require the Pennsylvania State Police to notify an individual when that individual becomes a prohibited person. Support organizations like the nonprofit Hold My Guns, and I believe the founder of which, Sarah Albrecht, is in the audience here and submitted written testimony and would welcome an opportunity at some point to testify before this committee. And provide funding for pro-rights mental health and behavioral health facilities so that individuals can seek out treatment without fear of stigmatization or their records being disclosed. Before I turn to any committee member questions, I want to address a couple points in relation to the testimony yesterday. First, contrary to the testimony yesterday, the issuance of an extreme risk protection order will strip in perpetuity the right of the individual to keep and bear arms pursuant to 18 U.S.C. 922G4 and the implementing regulation found in 27 CFR 478.11. I addressed this in a blog article that is specified and linked to in footnote 79 of my testimony. Also, while the Pennsylvania State Police yesterday correctly stated that the burden rests on it during a PICS challenge process, unfortunately, it doesn't impose that burden on itself. I have handled dozens and dozens of cases with the Pennsylvania State Police where I have had to appeal to the Attorney General because the Pennsylvania State Police does not impose that burden. Most recently, a case was SAMA, S-A-M-A versus Pennsylvania State Police, where the Pennsylvania State Police, in direct defiance of the definition enacted by this General Assembly, held that a person who was pardoned was still convicted, even though Section 6102 in the definition of conviction explicitly excludes an individual whose offense has been pardoned, and the Pennsylvania Supreme Court has consistently held that a pardoned offense cannot in any context constitute a conviction. The Pennsylvania State Police refused to accept that, required my client to pay an attorney, to take an appeal to the Attorney General, and then when we won in front of the Attorney General, took an appeal to the Commonwealth Court. Try explaining to your client why they have to spend thousands and thousands of dollars defending against these types of situations when the Pennsylvania State Police has a statute enacted by this General Assembly stating that its position is wrong. With that being said, I'd welcome any questions from members of the committee related to my testimony, the Mental Health Procedures Act, and the firearms laws. Thank you.
Thank you, Attorney Prince. I'd like to follow up on your comments regarding antidepressant drugs, and you specifically talk about selective serotonin receptor.
Yes.
We talked a lot yesterday about behavioral health and suicide and the prevalence of suicide, and I brought a point up of a family that I'm familiar with whose loved one was not in crisis, was waiting for 2 grandchildren, was in long-term recovery, and had medication changed. And it is their belief that that medication perhaps triggered the suicide. How much data do you have that shows the link between this and suicide as well? And if you could share that.
Absolutely, and in my written testimony, as you'll see, I've provided a lot of evidence, not just my bold assertions and beliefs, but actually evidence from multiple different sources, studies that are available, and declarations issued by doctors like Dr. Bregan that support that this has been known. In fact, it should concern everyone that Dr. Bregan's declaration was from 2001. He knew that much back then. Can you imagine what he knows today? but also what more the pharmaceutical industry is hiding from us. In one of the examples I gave there in Prozac being approved by the FDA, it showed that they knew of 20 studies, or they had conducted at least 20 known studies, I should say, but only ended up submitting 3 of those. And what's interesting is on the first and second submission, they were denied. The only difference between the second and third submission is not new studies. They just repackaged the same exact data in a new application. That should cause concern to everyone on the panel. Why are they hiding this information from the public? There is a lot of information that I believe can only be accessed if this committee does take the first steps in the nation to issue subpoenas and force the disclosure of these studies. If there's nothing to hide, they shouldn't balk or give any issue with turning over those studies to this committee.
Thank you for your recommendation. And just one follow-up on the 302 process and the concern of individuals not seeking treatment out of fear of losing their right for the rest of their life. That's an area that I think we would like to explore. And if you have any follow-up recommendations, some have suggested EPRO, others have said to me, well, we have an existing law. Should this law be modified to look at individuals who may be in crisis but aren't defined under the current law? Is that an appropriate location in the law for us to look to try to help those individuals?
I think looking at everything is worthwhile, and I know that there was some citation to an alleged situation that the individual said was not covered by the Mental Health and Procedures Act. I can tell you that that has not been my experience. In my experience, I see 302s issued and given out almost like they're Pez. I see doctors too concerned with making a bad decision and thereby committing everyone and anyone where there is a 302 petition. Although Pennsylvania's Mental Health and Procedures Act does specify that the least restrictive means are to be utilized in committing people, law enforcement generally is not aware of that, and doctors generally will just simply 302 someone without notifying the individual of any right to voluntarily commit themselves. I do law enforcement only training where we will go into a police department and explain to them what the firearms laws in the Commonwealth are. We discuss tools for the toolbox, and many officers are surprised to learn that they have that ability to talk with the individual and say, listen, if you agree to treatment and you go with me, this can be voluntary. You're not going to lose your Second Amendment rights. But if you refuse and you force me to involuntarily commit you, you're going to lose your Second Amendment rights. As I said, that's a tool for the toolbox for law enforcement, and I do think we need to do more to reach out to law enforcement and provide them with information regarding our laws, because unfortunately, it's very slow to trickle down to them. And generally, after a case is decided, it can take 2 or 4 years before law enforcement officers are informed of that case law decision or even statutory change.
Perhaps that's an area that we can take to the Municipal Police Officers Training Division. Before we offer it to other members for questions, I do want to acknowledge that Senator Art Haywood of Philadelphia and Montgomery counties has joined us. Senator Langerholk had a question.
Thank you, Madam Chair. Good afternoon. Thank you for your testimony. I agree with your testimony. I have one question with regard to some of the recommendations you make, and specifically, you're urging the passage of House Bill, I think it's 1066, Senate Bill 531, which is my bill regarding, you're familiar with it, regarding giving standing to organizations to sue municipalities and enact gun laws. My question specifically is, have you ever represented anyone in that capacity that was traveling to another municipality whose rights were infringed?
Yes, I've represented numerous individuals who have had their rights eviscerated because of local firearm laws and regulations that are directly contrary to the General Assembly's enactment of 18 PACS Section 6120. One of the more well-known cases is Justin Dillon versus City of Erie. I believe Mr. Dillon is in the audience today. He and 8 others were actually criminally prosecuted under an illegal ordinance by the City of Erie, even though they were successful in defending against those charges because of state preemption. They had no right to attorney's fees or costs. So it is a major issue. I have also represented on a number of occasions Firearm Owners Against Crime and Firearms Policy Coalition in challenging illegal ordinances, including the illegal ordinances that exist here in Harrisburg.
Thank you. Thank you, Madam Chair.
Thank you, Senator Langerholtz. Senator Haywood, followed by Senator Santasero.
Thank you so much, and thanks you for your testimony. You were sharing that the extreme risk protection orders that we tried to organize in a way so they could be temporary and short term, in fact could be permanent. And I believe you were laying out some kind of federal regime that would make them permanent. Would you please help share what is this federal framework that would make what we're attempting to do here in Pennsylvania, a temporary change, permanent?
Absolutely, Senator, and thank you for the question. It is somewhat of a lengthy and complex issue, which is why in footnote 79 I did specify the blog article I have where I have a more complex explanation so that senators and other individuals who are interested have some time to kind of digest it and understand it. But the issue is under federal law, specifically 18 U.S.C. 922 G4, which deals with, in essence, involuntary commitments as well as adjudications of incompetence and the definition of what an adjudication of incompetence is. And unfortunately, under the regulatory provisions that the Bureau of Alcohol, Tobacco, Firearms, and Explosives passed, found in 27 CFR 478.11, it includes any court order where the individual is deemed to be a serious threat to himself or others. And thus, under the specific language of the ERPO or Extreme Risk Protection Order bills that are pending, that would trigger that permanent disability. While Colonel Price is correct that on July 1st, 2019, the ATF verified or basically found that our relief provision met the requirements for an involuntary commitment, it is not clear that it would meet the requirements or that there's even a basis for an individual to petition for relief under 6105 F1 if there was an ERPO or extreme risk protection order placed against them. So it is my opinion that at the current time, if the bill as written were passed, it would absolutely cause that individual to be prohibited for the remainder of his or her life. And I just add, and I'm sorry, I don't mean to interrupt, I also believe that that could occur through the ex parte initial hearing because, again, you do have a court order that is now in effect relative to that person without any opportunity for that person to have been heard.
Thank you. I'm not sure exactly. I got a sense of where you are from your prior testimony, where you are in terms of the legislation. But I will ask you, would there be any help you would be willing to provide to us to make sure that the objective of having a short-term restriction is not permanent?
I am more than happy to lend all of my time to help this committee in any of its endeavors and provide guidance of issues. I have consistently done that and do that on our blog. We do have grave concerns about the due process consequences, but I would propose that I believe the proper mechanism is looking at our Mental Health and Procedures Act that already exists, and I believe that the 302 mechanism already provides exactly what this committee is looking for or what is sought after through an ERPO, provided we all enter into this with the understanding that the true purpose of an ERPO is to help the individual, not merely strip them of a constitutional right. That's why I believe you've seen such opposition from individuals, because truly it does appear to be simply a gun confiscation proposal. And that's why I do believe that we already have a framework in place through the Mental Health and Procedures Act, and that would be the best place to start, because we need to address the underlying condition of the person that's bringing us to want them to be assessed.
Thank you very much.
Thank you, Senator Haywood. Senator Santasero, followed by Senator Yaw.
Thank you, Madam Chair. Thank you for coming before us today, Mr. Prince. I take it by what you just said in response to Senator Haywood that you freely acknowledge that there are constitutional limits on the rights that are granted by the Second Amendment. You agree with that?
That would not be my own personal belief. I also would direct your attention honorably to Section 25 of Article 1 of the Pennsylvania Constitution, which already states that all rights specified in Article 1 of the Pennsylvania Constitution are inviolate, meaning they cannot be limited by the General Assembly.
Okay.
So I believe it would be the people that would have to act if they believed it appropriate to limit any of the rights specified in Article 1.
Okay, well, we can disagree on your reading of the Pennsylvania State Constitution, but I'm just trying to understand what your position is. So essentially, your position is that there is never a constitutionally permissible limit on Second Amendment or the state cognate rights.
I don't believe the Pennsylvania Supreme Court has ever weighed in exactly on what the breadth, let me say, of Article 1, Section 21 of the Pennsylvania Constitution is. Obviously, I'm sure you're acutely aware of the fact that the U.S. Supreme Court has weighed in on 2 occasions, only really one, though, addressing to the extent the quasi-breadth of it, and that was in Heller, where the court did say that reasonable restrictions were permitted. It did not go so far as to provide any basis of what is a reasonable restriction, and the district courts as well as the circuit courts have been trying to address those issues, and it seems that the U.S. Supreme Court is going to have to weigh in once again, and seems inclined to in a case in regarding New York State that oral argument, I believe, is to occur December 2nd.
Yeah, I'm trying to get a sense of your beliefs, however. For example, right now in Pennsylvania, we do have a background check requirement that covers actually many gun purchases. Do you think that requirement, for example, is a constitutionally valid requirement?
There is nothing in the U.S. or Pennsylvania constitutions that supports that background checks can be performed on a constitutional right. Could you imagine if we required such for the press? Before they could cover any instance or make any statement, they had to get permission and a background check performed on them. Why don't we have the same restrictions on the press? Why should someone who's been involuntarily committed be able to be a reporter? Why should someone who's committed a felony be able to be a reporter? These are concerns for me as well, but yet we never have that discussion. The only discussion and the only constitutional right that we seek to limit based on prior conduct is the Second Amendment, and that's of grave concern to me.
So just to be clear, you don't think we should have background check laws at all, even the current ones here in Pennsylvania?
I would simply refer to the Constitution, and we, the people, have the right to amend the Constitution. There is a reason that our founding fathers included an amendment process. It was not for the courts to simply decide to be judicially active and legislate from the bench. Our founding fathers were extremely intelligent. They knew if there came a time where the Constitution no longer met the requirements of we, the people, there was a mechanism in place for us to change it. That is what we need to return to, the amendment process where anyone believes that the Constitution is no longer applicable. And I will defend your right to amend the Constitution in any way, shape, or form you believe appropriate. Doesn't mean I'll agree with that amendment, but that is the framework which our founding fathers gave us.
So you referenced the First Amendment just a moment ago, talking about the press. There are defamation laws that apply to the press. Under the First Amendment, what we refer to colloquially as freedom of religion, there's actually 2 clauses in the First Amendment, one of which is the free exercise clause. And I assume you would agree with the statement that it is constitutionally permissible for states to pass laws that prohibit worshipers in the free exercise of their religion from, for example, engaging in human sacrifice, correct?
In engaging in what?
Human sacrifice?
There is case law from the U.S. Supreme Court to that extent. Again, it seems to be a hot-button issue at the current time, and it seems like there are a number of First Amendment issues going up before the U.S. Supreme Court where it may be inclined to change precedent in relation to the First Amendment. We've also seen how well those defamation lawsuits can be brought, especially when we have situations like Justice Kavanaugh and the allegations he went through without any recourse after it's been proven that they are false, and they continue. So I'm not so sure that those defamation abilities that you reference are that much supported by the Constitution.
Well, just to be clear, though, I mean, would you agree with the proposition that states should be able to prohibit religious groups from engaging in human sacrifice?
I believe that that is a decision dependent upon the people of that state and under their state constitution to decide. There is nothing under the U.S. Constitution that provides that mechanism. It is supposed to be, under the 10th Amendment, the right of the states to address all issues.
Senator, we're not here to grill the witness, and perhaps you may not agree fundamentally. I respect that, but he does have a right to his beliefs.
I'm not contesting that, Madam Chair. I'm not. I just want to get a better understanding of what his beliefs are. If I may ask one further question, with your indulgence.
Very quickly, if you don't mind. We have several others before we go to the next panel.
I understand that, and I'm trying to be respectful of that. Your organization, Firearms Industry Consulting Group, which it says is a division of civil rights defense firm, PC, does your organization receive any funding from gun manufacturers?
I don't know what you would intend by funding. We are a law firm, and we represent all facets of the firearms industry, whether it's individuals, federal firearms licensees, gun dealers, and all I do is legal issues. So yes, we receive, in relation to representing individuals as any law firm, money from those that we represent, but beyond that, I'm not sure what you're intending.
Does that include gun manufacturers, sir?
Federal firearms licensees that manufacture firearms are clients of mine, yes.
Okay, thank you. Thank you, Madam Chair.
Thank you. Senator Yaw, followed by Senator Farnese.
Thank you, Madam Chairman. Just one comment. You mentioned to a great extent the problem with drugs. And I have to admit, I never thought about that connection, but I've done, for the last 5 years, I've done a lot of work on the opioid problem. And one of the things that we found out about the opioid problem is that opioids were known to be extremely addictive. However, it was not disclosed, and in fact, it was marketed very, very heavily. So I kind of, thank you for bringing this up, but I kind of see somewhat of a potential for a pattern here when involving the pharmaceuticals, that your comment about the fact that it was not disclosed is, I mean, it's headline news now. Recently there was a court case, I think, in Oklahoma of a couple $100 million against one of the drug companies, and one of the major suppliers of OxyContin, I believe, is or plans on filing for bankruptcy. But in any event, so thank you for bringing that up. One question I had, you mentioned about the voluntary commitment, and I didn't understand it quite. You said if they go to somebody and they say, you have a choice. You can voluntarily be committed, or if you're involuntarily committed, then you could potentially lose your right to some Second Amendment rights. Could you explain that a little bit more, how that would work?
Sure, absolutely. Under both Pennsylvania and federal law, it is only an involuntary commitment that triggers any prohibition. So under Pennsylvania law, if you look to Section 6105C4, you will see that if someone has been what we colloquially call 302'd, it triggers a state law prohibition. Under federal law, it has also been the Bureau of Alcohol, Tobacco, Firearms, and Explosives position, again, based on their regulations, that anyone who has only been involuntarily committed is prohibited. Voluntary commitments do not trigger any type of prohibition. And again, the Mental Health and Procedures Act, in its implementing provisions, actually say that the least restrictive means are to be utilized, yet the courts have generally allowed a doctor to make that determination. Even if an individual wants to voluntarily commit themselves, the doctor can override that. And that's of grave concern, and I think that is part of the stigmatization that is occurring with mental health treatment, where individuals, and I've spoken with individuals who are scared to seek out treatment because they're fearful that they'll be involuntarily committed or that their mental health records will later be disclosed. And as I address in my testimony, I think it's footnote 4, although I could be wrong, there's been an evisceration of the psychotherapist patient privilege here in Pennsylvania, where now a psychologist or psychiatrist psychiatrist's opinions about the individual can be disclosed. That's had a monumental impact on individuals who might otherwise seek treatment. That's why I am asking this committee to investigate and propose legislation to enhance the psychotherapist patient privilege.
You talked about stigma, and as I said, in my work with opioids, stigma is one of the biggest issues that we've run into for people who are afraid or want to hide their addiction that we run into. So I understand what you're talking about when you say that. So thank you. Thank you, Madam Chairman.
Thank you, Senator.
Thank you, Senator Yaw. Senator Farnese, and I would like to note the presence of Senator Mike Regan of both York and Cumberland counties, who has joined us.
Thank you, Madam Chair. Thank you, Councilor, for your testimony today, and thank you for your written materials. I mean, you seem to have a very, very clear and very complete understanding of your written testimony. I see that there's some footnotes as well and some additional. The date on the document is September 25th. Is this 2019?
Yes.
Council, would you update this to the information that has been provided to the members? Would you say it's updated to the best of your knowledge and
Yes.
information?
Yeah, it was submitted as required last, I believe, Thursday, so that it could be distributed, but it was dated for today because of the fact that the hearings were for today.
And I'm just assuming this is, I guess in your practice, you would go, if things change or you see different information come up, you would amend your materials. Is this packet that you handed out? I mean, as things change, you certainly keep it up to date, I would assume, correct?
I haven't generally, I don't have a policy or procedure when I testify to keep updating testimony beyond when I send it into the committee. Obviously, if there was an important issue that I believe had arisen, obviously I'd be more than happy to address it during verbal testimony, or, you know, if I felt it was so important, I could see myself submitting a supplemental or addendum written testimony.
And what about with regard to the, throughout your testimony, one of the points specifically, universal background checks. You sort of have a lengthy part in your testimony about your position on that and your disagreement with that. That is up to date, sir? Is that what you've provided to the committee?
It is to the best of my knowledge.
Okay, so on page 26 of your testimony, my question would be this. You state that the state of Pennsylvania currently does not require background checks, as you know, for the sale of rifles or shotguns between private parties. That's correct.
And that's correct, consistent with what Colonel Price testified to.
Right, okay. And so, there's no known instances in Pennsylvania of individual acquiring a rifle or a shotgun through a private party sale, correct?
That is correct. However, the law does specify that if they have any basis to believe that the person is prohibited, they can't make the transfer, and obviously they would be subjected if they did knowingly transfer that firearm to someone who they believed or knew was a prohibited person of felony charges.
Okay. And did you do any investigation to find out if there are any cases that have been prosecuted or on the books in terms of between private citizens?
I am not aware of any, and as I put in my testimony, I have consistently reached out to Shara Goodman with Ceasefire PA, and we've debated this issue on a number of occasions before, and I always ask her, do you have any actual instances where someone unlawfully, obtained a rifle or shotgun through a lawful transfer where that person ended up being a prohibited person?
Listen, maybe I could just help you with this. So we actually spoke to the district attorney's office. I don't know if you had an opportunity to speak to them and ask them the same question.
I did not.
But actually, we can answer your question that the adult shot of a law enforcement officer sold an AR-15 by a private sale without a background check in August of 2019. There's some article was written about it on August 20th as well, too. I'll give you some more information.
And that was here in PA?
Yeah, so 2 years later, the individual sold the AR-15 to Douglas Gonzalez by a private sale without a background check. Mr. Gonzalez was convicted drug dealer and was not permitted to legally purchase a gun. Agents of the Attorney General were executing yet another search warrant for narcotics and illegal possession of a firearm and found the AR-15 under the mattress on which his infant was sleeping. So again, this is an instance where background checks, you say, are not necessary. They're not needed. This is clearly an instance, sir, where not only did it happen, but a background check, I think, at least in my opinion, would have played a role in stopping that from happening.
I'm sorry, I have to disagree with you, Senator. All the laws on the books aren't going to stop criminals from committing criminal acts. You can always find an instance where a criminal is going to commit criminal acts. It's part of the name. And it goes back to the old adage, if we only had laws against murder, it wouldn't happen, right? It doesn't happen. All these laws do is impose restrictions on law-abiding citizens. It's not going to stop crime. And you're teasing yourself if you believe it is. And I know you're a very smart man. I know that in your heart you know that all the laws on the books aren't going to stop criminals from committing criminal acts.
Well, look, I don't think that you and I, there's enough time that we can go back and forth in terms of our position. I'm not going to certainly get the chair, and I appreciate your indulgence, madam. I certainly can't agree with your testimony. I certainly appreciate you coming in here today, but I could just say this, that the way in which you've described, specifically in response to Senator Sanacera's comments about the First Amendment, you responded in terms of restrictions, and you sort of commented on the Supreme Court that, best of your knowledge, there are no the restrictions put on the Supreme Court. Personally, yourself, do you believe that there is any restriction, a reasonable restriction, that could ever be placed upon the Second Amendment? Do you think there is anything that you could come up with that you think that could be permissible, constitutionally, in your opinion, as a counselor, as an attorney who handles these cases? Now, you came and you said, in your personal opinion, you said, how about your professional opinion?
In my professional opinion, I am obviously bound by the decisions of the Pennsylvania Supreme Court in relation to Pennsylvania law and the U.S. Supreme Court in relation to federal law, including the U.S. Constitution. And I acknowledge the fact that the U.S. Supreme Court has issued a plethora of decisions relative to all constitutional provisions, somewhat eviscerating what my own personal opinion would be of those constitutional rights. And yes, we are bound as attorneys by those determinations, as well as the Republic is bound by those decisions. Whether they're right or that, I think is beyond the scope of today's hearings, but you asked me for my opinion, and that is it.
So it would be fair to say that you don't believe there's any kind of reasonable restriction that could be placed upon the Second Amendment, period?
My own personal opinion is that that would require we, the people, to make that decision and to amend the Constitution.
I'm just going to shift gears here before I wrap up, and thank you, Madam Chair. With regard to the fees, I think one of the questioners asked regarding pay. Is there any instance where, for instance, the NRA or a gun manufacturer may pay you in order to prosecute cases for your clients? Do you ever receive payment from manufacturers of guns or the NRA?
As I testified to before, yes, when I'm representing a client, obviously they may be paying me. I do a lot of pro bono work, so I don't always get paid. But yes, absolutely. I mean, I represent federal firearms licensees that are manufacturers, importers, exporters, just regular dealers. And when I'm representing them, generally I'm being paid.
By them, directly. How about, and as what percentage could you give me possibly, if you could tell me, with regard to your practice that you receive payment from gun manufacturers?
Senator Farnese, I don't know that this is appropriate. I don't believe we should be asking our groups coming before us. I don't intend to ask those who come from other organizations where they derive their funds. So I don't think that that's a fair or appropriate question at this time. So at this time, please, no. I ask you to have respect, and I realize that this is, as I said at the onset, it's going to be a passionate conversation. And if you would like to ask that question of the attorney outside of here and he chooses to answer it, I think that would be appropriate.
Just one before he leaves and he's under oath. Counsel, would you be willing to?
Obviously, I have attorney-client privilege, so depending on exactly what is being asked of me, that may come into play. I'm not sure I have a clear understanding of exactly what the information is that you're seeking, but obviously to the extent you want to put it in writing and provide it to Chairwoman Baker, I am more than happy to consider it, and I would respond to her if I believed it appropriate.
Thank you.
Thank you, Senator Farnese. Thank you, Attorney Prince. And I know we're running somewhat late. We appreciate your testimony and thank the indulgence of all the members and those in attendance.